Welcome to FCPA Flash, the official podcast of FCPA Professor, moderated by Professor Mike Kaler. FCPA Professor is the leading source of daily FCPA news and commentary and the most authoritative source for those seeking to understand and apply the FCPA. To learn how FCPA Professor can elevate your FCPA knowledge, please visit www.fcpaprofessor.com.
Thank you for listening to the FCPA Flash podcast. This is Professor Mike Kaler, and I invite you to my next FCPA Institute in Nashville on May 3rd through the 4th. To learn more about the two-day FCPA Institute and how it has elevated the FCPA knowledge and practical skills of a diverse group of professionals, please visit fcpaprofessor.com and click on the FCPA Institute page. Welcome to FCPA Flash. This is Professor Mike Kaler. I'm pleased to be joined today by Michael Levy, a partner in the investigations and white-collar defense practice at Paul Hastings and based in the firm's Washington, D.C. office. Thanks for joining FCPA Flash today.
Thanks, Mike.
Now, you recently wrote an article titled The SEC's Unlawful and Dangerous Expansion of the Exchange Act that caught my eye. The article asserts that the SEC has, quote, ventured far beyond the authority that Congress granted in the FCPA's accounting provisions in bringing several enforcement actions. Before turning to the substance of the article, what motivated you to write this article?
I actually vividly remember being in my kitchen one morning and reading the Wall Street Journal, and there was an article about the SEC's resolution with United Continental in connection with United's offering to reinstate a flight between South Carolina and Newark in an alleged effort to curry favor with the chairman of the Port Authority, who had a vacation home down in South Carolina. And I remember thinking to myself, what in the world does this have to do with the SEC? It didn't involve foreign bribery or the FCPA. It didn't involve securities law issues or disclosures. And it didn't involve accounting issues or accounting fraud. So I really couldn't understand why the SEC thought it was its business to regulate this particular part of private corporate conduct. So I decided to take a look at the resolution of the matter, and as I was reading it, I just got more and more annoyed because it seemed to me to be really an extension well beyond even the intern hiring cases involving some of the banks to an area where the distinction between what the SEC is by statute supposed to be enforcing and what they're actually enforcing just seem to be astronomical and irreconcilable with the statutes that they were using to enforce the conduct.
And just for listeners' benefit, this United case was not a FCPA case in the traditional sense of the word. It did not involve alleged bribery of a foreign official. But because the FCPA's books and records and internal control provisions are very generic and very flexible, the enforcement action did involve the same books and records and internal control provisions we frequently discuss in more traditional FCPA cases.
Yes, and in fact, I think, Mike, you just inadvertently put your finger on a huge part of the problem here, and a huge part of the difference between what those provisions actually say and how they've been used recently by the SEC. And that's that people tend to call these provisions the, quote, internal controls, close quote, and, quote, books and records, close quote, provisions. But that's not actually what these provisions are. And so we've all gotten ourselves hoodwinked to some extent into believing and thinking about these provisions as the SEC and DOJ having the authority to bring actions when there are any internal controls that fail or when there are any inaccurate books and records. That's just not what the statute says, and that's what the article really digs into. and I hope you'll put a link to the article up on your site so people can read the more detailed analysis.
Yeah, no, I highly encourage podcast listeners and FCPA Professor website listeners to read the article and wrestle with the issues I think you rightly identify. Again, let's just get the law out there. The books and records provisions say issuers have an obligation to keep books and records which, in, quote, reasonable detail, accurately and fairly reflect the transactions and dispositions of the assets of the issuer. And then the internal control provisions basically require issuers to have sufficient controls to provide reasonable assurances that certain specified financial objectives set forth in the statute have been met. Now, in your article, you talk about the SEC unlawfully expanding the Exchange Act, and then you follow that up by saying, well, this is a dangerous development. What makes this expansion, in your words, dangerous?
Well, I think it really gets back to the point I was making at the beginning of the podcast, which is that if you believe that the SEC has the authority to regulate through enforcement all internal controls of any issuer or all books and records of any issuers, not those internal accounting controls. That is the actual language of the statutes, not just internal controls, internal accounting controls, a very specific subset of internal controls. That limitation is incredibly important if we're going to avoid the SEC essentially becoming an uber regulator of all aspects of American or, frankly, international business. That's not the role of the SEC, and that's not the power that Congress gave the SEC in passing the internal accounting controls and books, records, and accounts provisions of the FCPA 40 years ago. I think it's important because when you look at such an expansive definition of internal accounting controls, for example, it not only completely ignores the statutory language and the clear congressional intent, which the article gets into, in distinguishing between internal accounting controls and what at the time the SAS 1, which is where the provision that became the internal accounting controls provision actually came from virtually verbatim, deals with internal administrative controls. So those things that a company uses to run its business, to make management decisions, those are internal administrative controls and not internal accounting controls. But if the SEC starts to believe that it has the authority to regulate all internal controls, including internal administrative controls, such as a decision about whether or not to offer a particular airline route to customers, then the SEC basically has the ability to go back and bring an enforcement action under the books, records, and accounts provisions and the internal accounting control provision for just about any management decision it subsequently disagrees with. I think that's what happened in United. I think it's fundamentally dangerous because the SEC doesn't have the institutional knowledge and expertise or mandate to regulate every aspect of every business. You would imagine, for example, that if an administrative agency were to regulate the conduct of an airline in deciding which airline routes to offer to the public, it would be the Department of Transportation, not the Securities and Exchange Commission. I think that difference makes it very, very dangerous.
And just so we're clear, I'm 100% certain you'll agree with this, that we're not talking all FCPA enforcement actions here. There are many corporate FCPA enforcement actions which would seemingly involve clear-cut, slam-dunk violations of these accounting provisions. You'd agree with that, right?
Absolutely.
Yeah.
It cuts to the core of what Congress was really worried about 40 years ago when they passed these provisions, which is you write down in a genuine book, records, and account sort of journal that you spent $100,000 on a certain expenditure that is not actually what you spent the $100,000 on. What you really spent the $100,000 on was a bribe of a public official in a foreign country. That's a clear violation of books, records, and accounts. And If your controls were not sufficient to prevent that, it's a violation of the internal accounting controls as well. Those are the types of books, records, and accounts that fail to fairly reflect the transactions and the dispositions of assets. That is what happened to that $100,000.
And as you know, go ahead.
The United case is completely different. The intern hiring cases are completely different. That's about how management decisions are made, not how transactions are recorded. And the article obviously goes into far greater detail about exactly what those differences are.
Yeah, we are increasingly seeing in recent years this expansion, this dangerous expansion. You note in the internship and hiring cases, it was largely, internal compliance questionnaires were the alleged false book and record. I recall the BHP Billiton enforcement action concerning Olympic tickets. It was, BHP Billiton was an official Olympic sponsor, obviously got free tickets, and some of their internal planning documents associated with distribution of these tickets was allegedly problematic. But, again, I think it's important, and I face this issue a lot in my writing as well, that just because you're raising a red flag as to certain creative, expansive, dangerous enforcement theories does not mean that you're anti-FCPA, does not mean that you don't recognize that there's some clear violations here, but that's not what we're talking about.
Yes, that's absolutely correct. It's a stretch well beyond what the legislative language and legislative intent was that is the problem. Stuff that falls within the heartland is clear under the law, falls within the FCPA, is subject to the SEC's enforcement jurisdiction. I don't think there's an argument about that. The problem is when things get pushed so far that they genuinely are not recognizable when you look at the actual statutory language and legislative intent, that we have a real problem.
I mean, some people might be inclined to view your article as provocative. I kind of view it as just a traditional nuts and bolts rule of law. An enforcement agency only has the authority to enforce a law that Congress passed type analysis. And I think many people who value the rule of law and that traditional statutory construction type analysis will agree that the issues you identify in your article are problematic. That's an important first step, perhaps. But the more important question becomes, I think, okay, what do issuers and their counsel do about this?
I think it's very challenging because as I've written in a guest blog post for you before, there is a dynamic that occurs between publicly traded companies, issuers, and the SEC in resolving these matters that almost encourages the distortion of the law in this way. And that's something I've referred to in the past as prosecutorial common law. The idea that the set of incentives for the settling parties in an investigation like this sets up a dynamic in which the company is seeking to settle in the manner that best achieves the objectives that benefit its shareholders. That is largely drive the fine and penalty down as much as possible and resolve the problem rather than taking the charge and the public opprobrium and likely stock price drop that would accompany that. In contrast, the commission, or the government, DOJ in that context, doesn't have the same set of incentives and actually will benefit from the company agreeing to a legal theory or set of facts that will allow it to push the law just a little bit farther. It happens a lot, frankly, when you have a situation where the government spent a lot of time and resources investigating something and may not quite have as good a case on the law and the facts as it had hoped for. But it knows it can get the company to settle for something just to get rid of this. And the United case was a simple case for United to resolve. It resolved it for, if I'm recalling correctly, $2 million. $2 million is nothing to United, far less than they would have paid in legal fees alone to litigate the matter. And they resolved it and got rid of it. In order to do that, when there wasn't much to go on in order to resolve it, the SEC had to come up with a legal theory that it thought would survive, and it was an extraordinary one. And United, although I'm sure they wanted to fight it, ultimately made a completely rational decision from their perspective to simply agree to it, take the $2 million fine, and get over with it. The problem with all of that is the word I've never mentioned is judge. There's not a neutral arbiter, a judge, involved in assessing these settlements. And so what winds up happening is the law gets, quote-unquote, developed through a series of settlements that aren't actually judicial decisions by neutral decision makers. So the law gets pushed and pushed and pushed and pushed because if Company A agreed that this was a violation, then clearly Company B will agree to it as well. And don't you think adding this little piece to it makes sense to Company B? Till you get to the point where ultimately the SEC's view of the law or the Department of Justice's view of the law is so completely at odds with the fundamental statutory language and legislative intent that somebody challenges a case, takes it up to the Supreme Court, and consistently the Supreme Court rejects the government's interpretation, essentially 9-0. It happened in Arthur Anderson about obstruction of justice. It happened in Skilling about honest services fraud, and it happened last term, albeit 8-0, in Kokesh about disgorgement statute of limitations for the SEC. So I see the same thing happening here, and the question is just, is either someone going to be able and financially willing to challenge this thing, to take it all the way, to make it clear that this is not the law, or will the type of public discussion that I'm hoping to generate through this article and maybe this podcast as well, so that the commissioners themselves take a look at this issue and say, wait a second, we don't want to be doing something that's illegal, even if we can force companies to agree to it.
Yeah, you've done a nice job re-summarizing your prosecutorial common law post on FCPA, Professor. And if listeners haven't read that, I highly encourage it. It was probably about 6-7 years ago you published that post, but as you articulate, the issues really haven't gone away. It's titled Prosecutorial Common Law. So if you're looking to assign blame here, is this the SEC's fault or is this company's fault? And I think the truth is, probably somewhere in the middle, given excessive risk aversion. And you make the spot-on observation that in isolation, the board of directors, the audit committee members of a particular company is making a rational business decision that is probably in the best interest of their shareholders. But the problem is when you aggregate company A's risk-averse business decision, company B's risk-averse business decision, so on and so forth, you get, as you note, this ever-increasing, escalating, expanding area of law when the fact of the matter is these are all just risk-averse corporate settlements. And in the FCPA is, of course, 40 years old now. To my knowledge, an issuer has never in 40 years put the SEC to its burden of proof in an FCPA enforcement action. And the SEC will say, well, that's always an option. But how do we break this logjam if we think of it that way?
Yeah, I think for the reasons we articulated, it is often not a realistic option for a publicly traded company because of the impact that a charge would have on the stock price. I think the reality is that companies have the obligation to follow the law, and the government has the obligation to not bring an enforcement action, which includes a settlement, if the conduct does not violate the law. And I think it's time for the SEC to take a close look at whether it has gone too far. Simply because you can get somebody to agree to a resolution doesn't mean that you should. And I think back to my days as an assistant United States attorney in the District of Columbia, where it was very clear to me that a decision to not bring a case, if the case was not warranted by the law and the facts, was perhaps the most important thing I had to do if the situation called for it. And there are a number of situations in which, as a prosecutor or a government enforcement lawyer, like an SEC enforcement lawyer, where you know that because of the enormous power that you have over a company or an individual, because of the enormous consequences that the company or the individual could face if they roll the dice and lose, can force companies and individuals who didn't actually violate the law to agree that they did, to plead guilty or to agree to settle. Just because you can get somebody to do that doesn't mean that you should. And I would hope the SEC will just take a fair and rational look at what the actual facts and what the actual law is on some of these matters and say, we've looked at this, we've investigated, we're concerned about what happened, but we don't believe that it falls within the statutory language or the legislative intent. And accordingly, we are going to decide we're not going to bring that case. That is justice.
Right, and you mentioned the SEC and DOJ, for that matter, should be more disciplined in not bringing some of these enforcement actions. But just to take a step back, when you look at how some of these aggressive, overly expansive enforcement actions originated, they're actually through voluntary disclosure. One that comes to mind is the Oracle enforcement action from probably 5 years ago. I remember at the time writing Oracle, an FCPA enforcement action that diluted FCPA enforcement to a new level. And you take a look at that and you're like, why in the world was this enforcement action brought? But then again, you dig into the details, it was a voluntary disclosure. So I've often wondered, if I'm an SEC attorney and high-profile law firm A contacts me telling me why their client may have violated the FCPA, what am I supposed to do in that situation? Say, well, thanks for calling me, but you shouldn't have? So what do we do about the fact that both in terms of expansive enforcement of the anti-bribery provisions as well as expansive enforcement of these books and records and internal control provisions, they actually originate with voluntary disclosures, some of them at least?
Yeah, but a voluntary disclosure does not mean that a crime has been committed, and that's or a violation of the FCPA in the SEC's vernacular. I think you have to look at the set of incentives. The incentive for a company in dealing with a situation like this is, if there is any possible risk at all, there is a strong argument to be made for disclosure. And key to that analysis is the idea that, look, we might be right, we might be wrong. We hope and expect that the government will look at the facts in the law here and make a reasonable judgment on their own about whether or not the law actually was violated. But we want to protect ourselves, so we're going to let them know about it. We're going to argue that it wasn't a violation of the law, but we're not going to hide it for them, because if we hide it for them and they decide that it is a violation of the law, we're going to be in much worse shape. The calculation on that from the perspective of a defense lawyer like I am is always complicated, and it differs in every case, but you can easily understand why a company would do a voluntary disclosure, even in a situation where they believe overwhelmingly the conduct does not constitute a violation of the FCPA, but there is some theory that somebody might think about, and they decide to be safe rather than sorry, they'll go ahead and they'll self-disclose. That doesn't mean the SEC ought to bring a case. The SEC has an obligation to take an independent view of the facts and the law and decide whether, in its judgment, it actually is a violation of the law. And particularly where there's so little judicial oversight, it's incumbent upon the SEC to take that obligation extremely seriously. Again, just because they can bring an action doesn't mean they should.
And
That's the commission. And ultimately, I think the commissioners have to hold the Division of Enforcement responsible for that. And one of the big problems here is that if there's a settlement, the commission never actually gets to address these kinds of questions like they would if there was a Wells submission and a potential charge being debated. I think that's a big risk. The other risk from the government's perspective is if you're spending a lot of time and resources investigating, prosecuting, and settling cases that are marginal, like the ones that we've been talking about, you're distracting resources from the core situations, the core cases, the real problems that you could be better spending your time on. I mean, bringing a case inevitably means there's some other investigative enforcement conduct that's not being done while that case is being brought. And that trade-off becomes less and less productive the more extreme the legal interpretations get.
Yeah, I think I was an FCPA lawyer in private practice for nearly a decade, and my observation is I just really think there needs to be more discipline by FCPA lawyers in general in making these voluntary disclosures. I know the facts and circumstances of every case are unique, but the notion that FCPA lawyers are voluntarily disclosing conduct that may perhaps, under some certain theory, violate the law, I think that is problematic and is part of the total mix of information that is perhaps relevant to what is going on in this space.
Yeah, I think most sophisticated practitioners in this space will understand that there are situations in which a voluntary disclosure does not make sense, and it's perfectly appropriate and reasonable not to voluntarily disclose in certain circumstances. I think the key, and ultimately what clients pay their lawyers to do, is make those difficult judgments about when it is appropriate and when it's not appropriate. You're not doing your client any service if you simply decide every case is voluntary disclosure. It's figuring out which ones are and which one aren't. That's the real trick.
Yeah, I think it's you can really ask two questions in relation to most instances of FCPA scrutiny. The two questions are similar but yet distinct. One question is this the type of conduct that the DOJ and the SEC might bring an enforcement action on? And we can often answer that question yes. The second question, I would say the rule of law question, the more important question is this the type of conduct that Congress, in passing the FCPA, sought to capture? And is this the type of conduct that, if a court were given the opportunity, would find in violation of the FCPA? A lot of times the answer to that question is an open question mark because we simply don't know.
And as my article points out, in some instances, it's not ambiguous at all. It's a clear no. I have absolutely no doubt, and I think the article is written from the perspective that just like the Supreme Court had no problem in Arthur Anderson or Skilling or Kokesh, this is a really easy question from a rule of law perspective. And it is very, very disappointing that such an easy question is still so frightening from the perspective of the first question of would the SEC actually bring a case? Could they have?
You were a former Supreme Court clerk and obviously know how the Supreme Court works better than most. I was involved heavily in the foreign official challenges, including writing an amicus brief to encourage the Supreme Court to hear the Esquinanza appeal. The challenge I faced in the amicus brief was, how do you get the Supreme Court to hear a case when there's only one appellate court decision in the country on this issue? But part of the challenge there was explaining to the Supreme Court why that's the case. And why that is the case is given how the DOJ and the SEC have chosen to enforce this statute and the ease in which these cases are resolved in the complete absence of judicial scrutiny. This was the Supreme Court's one opportunity in literally 40 years to address arguably the most important legal element of a very important federal statute. And of course, not surprisingly, given that there was only one appellate court decision, they didn't hear it.
Yeah, it's very difficult. I think it would ultimately take a recognizable corporate name to challenge this, to get the justice's attention. I think that's highly unlikely. And again, while I would encourage clients to seriously consider the prospect of a legal challenge when the SEC's legal theory is so clearly at odds with the statutory language and legislative intent, I think in the immediate context, what we can do is continue a clear, open, public discussion with members of the FCPA and SEC bar, because as you noted, the internal accounting controls and books, records, and accounts provisions are not limited to foreign bribery cases. They apply to every issuer in every context that relate to internal accounting controls and books, records, and accounts that allegedly don't fairly describe transactions in the disposition of assets. It does not have to do only with foreign bribery, so it affects the SEC enforcement bar quite significantly as well. If both of those bars can start a significant conversation about these issues and sort of put it to the SEC, not only the Division of Enforcement, but the commissioners themselves, I believe that commissioners who are sworn to uphold the law, that the directors and senior folks at the Division of Enforcement who took a similar oath to protect and defend the constitutional laws of the United States, if this conversation is had in a reasonable, rational, thoughtful way, I hope my article begins in that way, I think that hopefully people will come to realize this has gone too far and we ought to do the right thing and enforce the law as it's written, not as we want it to be written.
Today's guest has been Michael.
I may be wrong, I may be delusional, but I think right now that's a conversation that I would welcome, because I would really want to hear what other explanation the SEC has for how some of these cases fit within the statutory language and legislative intent, because they just don't, as my article makes clear.
Yeah, no, I agree with you on that. I've tried to inquire with SEC enforcement officials myself what was the rationale and explanation for this enforcement theory, and they're very tight-lipped on that, and we don't get much explanation. But thank you for joining me today. The guest has been Michael Levy, and he's a partner in Paul Hastings in Washington, D.C., and I highly encourage you to read his article titled "The SEC's Unlawful and Dangerous Expansion of the Exchange Act." Thanks, Mike.